Sir, in about a minute, can we start the program?
Sure.
Yes. Good evening and a warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru in association with Advocates Academy Bengaluru. We have a very special personality with us, a leading lawyer, Mr. Lomesh Kiran, Advocate, High Court of Karnataka, partner, Head Dispute South India, Cyril Amarchand Mangaldas. Sir, we are honored to have you on this platform. On behalf of Advocates Academy Bengaluru, Association Bengaluru, and my personal behalf, sir, I extend a very warm welcome to you. The topic that we have chosen today is media trials and gag orders. Sir, as we were just discussing a while ago, the famous or infamous Jessica Lal's murder case. I think perhaps it takes us there. And beyond that, I would not want to say anything. Over to you, sir. And before that,
Yeah,
sir,
thank
it's a privilege to mention about this. You have been ranked as a leading lawyer. And I use that word leading lawyer. It's not just on a lighter note, but you have been ranked by various publications. And you have been practicing not just restricted to India, but beyond the territorial jurisdiction of India. So, how would you feel, and what is the piece of advice to the upcoming and budding lawyers, sir?
Well, firstly, thank you so much, Trivikram, for having me here. I know you and I have been speaking about this for quite some time. So thank you to the Advocate Association Bangalore also for extending the invitation to me. Uh, and regarding your question, so please, all those awards or accolades, I take it all with a pinch of salt. So for me, I just consider myself as a student of law, and for me, every day is a learning. And it's just the curiosity of law that keeps me going on a daily basis. So I don't have much to sermonize or tell the younger lawyers except to say that, stay true to your passion and rest will follow.
Definitely, we would. I would like to ask more questions at the end of this session, just to motivate the youngsters. Of course. Now over to you for the actual topics, sir.
Great. Thank you so much, and thanks to the audience also for joining in. I would invite as many questions as possible, so it's and like to make it as interactive as possible. But I understand that we have an hour, so maybe what the way we can structure it is that I'll try to give as much data as possible, and I'll keep sufficient time for Q&A because I really think that the soul of any conversation comes down to the Q&A, and if I'm able to address as many questions as possible. So please keep your questions and your thinking hat ready. The topic that we're dealing with today is media trials and gag orders. Now, this topic assumes immense significance in today's times, especially with the growth of social media. You see a lot of news that just spreads like wildfire in the media. Now, in a democracy like India, and like with any other democracy across the world, there are always conflicting rights. So there are two rights which are always in conflict with each other. And in this particular case, which concerns this particular topic, is Article 19 of the Constitution of India, which guarantees people to express their views freely and Article 21 of the Constitution of India, where there is a right of an individual to have his or her dignity and reputation, and in a sense, a right not to be defamed. Now, how do you balance these two is something that most jurisdictions across the country have really struggled with. And each country and each jurisdiction has found its own niche in terms of how to balance these two rights. Now, the presentation that I will be taking today will take what I intend to do is take you through some of the leading case laws in India and also take you through the jurisprudence in other jurisdictions as well, so that we're able to better analyze as to how our jurisprudence also has evolved with time. Now, to give a context, I think gag orders and media trials, this is something, as you rightly said, the Jessica Lal case, Trivikram, that you referred to. Likewise, there is the Darshan case. Now you have the Dharmasthala case. Then you had various other cases of the Supreme Court and various high courts, where the courts have always grappled with this question of how do I balance the two rights? Does the press have an absolute right to publish anything and everything, whatever is going on in the world today? Or is there a corresponding duty on them to ensure that the reporting is fair, the reporting is right, and adheres to certain standards? Now, that is something that we will go through during the course of the presentation itself. Now, just to give you a historical context, now one of the most famous sayings insofar as freedom of speech and expression is by this person called Voltaire, who once said, "I do not agree to what you have to say, but I'll defend to death your right to say it." I think that is the essence of democracy. The fact that you may not agree with what the other person is saying, but you still defend the right of that person to say what he or she wants to say. And that fulcrum of our fundamental right is enshrined in the Constitution of India, where one of the most important articles in the Constitution of India is Article 19, which gives every citizen of this country the right to freely speak and express his or her thoughts or views, subject, of course, to the restrictions under 19.2, which restriction you don't find in other jurisdictions, but 19.2 circumscribes certain limitations insofar as the speech is concerned. But barring that, people have the right to express their views. Now, I'm also reminded of a saying, or rather a quotation, in Subramania Swamy versus Union of India, 2016 7 SEC 221, which was a judgment of the Supreme Court where there was a challenge to the validity of sections 499 and 500 of the IPC, which pertain to criminal defamation. Now, various challenges were taken to that particular provision, and the Supreme Court ultimately relied on the Bhagavad Gita to essentially say this. This is the English translation, which is, "Men will recount thy perpetual dishonor, and to one highly esteemed, dishonor exceeded death," which is that nothing is more dearer to a person than his or her reputation. Now, if a reputation of a person is besmirched, then there is nothing left for that person. And in fact, Bhagavad Gita goes on to say that dishonor is worse than death. Now, that is where the two conflicting rights need to be harmonized. That is, your right to speak whatever you have to say, even if it is something that's uncomfortable against you, versus a right where a person cannot be defamed, because if you're defaming him, there is nothing worse. Even death will not be enough. So that is what Subramania Swamy says. This is just to give a broad context to the discussion. And of course, the audience would be well aware of Article 19.1a of the Constitution and Article 19.2 of the Constitution. Article 19.2 circumscribes certain situations where there is no freedom of speech and expression. That is where it involves sovereignty and integrity of India, security of the state, friendly relationship with foreign states, public order, decency, morality, contempt of court, and most important, defamation or incitement to an offense. So even defamation is one of the exceptions which have been provided to under Article 19.2 of the Constitution. So while there is a right to speak, there is also a corresponding duty not to defame somebody in the eyes of the public. So I think that is an important aspect to keep in mind. Now, before I get into the Indian case laws, let me just give a broad context of how the law is positioned in various other jurisdictions. Now, under the European Convention of Human Rights, that is Article 10, there is a blanket right which states that everyone has a right of freedom of speech and expression. And subsection 2 carves out certain exceptions like interest of national security, territorial integrity, public safety, prevention of disorder or crime, protection of health, morals, protection of reputation of others, disclosure, etc., etc., which are largely akin with Article 19.2 of the Constitution of India. Now, let us analyze what is the jurisprudence in England. Now, England, unlike India, has a very different regime. Now, the English courts will only grant an interim injunction when the following four conditions are met. That is, one, the statement is unarguably defamatory, which is a very high threshold. Two, there are no grounds for concluding the statement may be true. Three, there is no other defense which might succeed. Or four, there is evidence of an intention to repeat or publish the defamatory statement. And there is a judgment of Bonnard versus Perryman, which is an 1892, the House of Lords judgment, where essentially the court lays down a very, very high threshold. And the threshold is that if a defendant goes to court and says, whatever I've said is true, and I'm going to prove the truth during the course of trial, and unless the court finds that the defense is absolutely malicious and something that cannot sustain on the face of it, injunction to pass any kind of a gag order would not be passed. So that is why UK has developed this unwritten kind of infamous reputation of being the defamation capital of the world, simply because a lot of defamatory statements can be made in the UK, which perhaps will not pass the scrutiny of other jurisdictions. But in the UK, because of free speech and because of the test laid down in the Bonnard case, it is very difficult to get any kind of an injunction order. And likewise, the jurisprudence in Canada as well. Canada again has followed the UK principle under Bonnard case, and essentially they've said that it is a very high threshold that needs to be made. And in fact, the Compass Group Canada case versus Hospital Employees Union, which is a 2004 judgment of the Canadian Supreme Court, essentially says that the defamation is to be granted, and a gag order restraining any kind of defamation can only be granted in the rarest and clearest of cases. So the test is rarest and clearest of cases, which again is a very, very high threshold and not easy to surpass. Likewise, the jurisprudence in Australia, they have taken a slightly middle approach compared to both the jurisprudence in England and Canada. They have said that while the Bonnard case may not apply directly to the facts of to the scenario that is in Australia, but largely they have said that if there is some justification, then they can pass it, but largely steering towards freedom of speech and expression. Now, the jurisprudence in the United States of America again is quite interesting. Now, in the US, the very first amendment, they have different amendments, like the articles in the Indian Constitution. The very first amendment of the US Constitution guarantees free speech and press. In fact, I'll just read it out. It says, Congress shall make no law respecting establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press, or the right of the people peacefully to assemble, and the petition and to petition the government for redress of grievances. Essentially, the First Amendment says there is, and unlike 19.2 of the Constitution of India, there is nothing in the First Amendment of the US Constitution which prescribes certain restrictions on the manner in which the freedom of speech and expression has to be evolved. In fact, from the case laws that I remember reading from the US, in the US, in the guise of freedom of speech and expression, a person can go to the extent of even burning the US flag and saying that the policies of the US government are not right and burning it. So that is the extent to which the freedom of speech and expression has been given importance to. And insofar as the public morality and sovereignty and other aspects are concerned, it takes a backseat. In fact, it is not even mentioned in the US Constitution. And likewise, that is the reason why the New York Times versus Sullivan case uh, specifically states that the gag order or some kind of a restraint on publication of a certain material can only be passed if the plaintiff is able to show that it has been made with malice, that is, with actual knowledge of the falsity of the statement or reckless disregard to the true state of affairs. Now, in order to show malice again, it is a very high threshold. And typically, even in the US, getting injunction orders becomes very, very hard. And likewise in Singapore as well, Singapore has a slightly more guarded approach where they have made exceptions insofar as the rights of children, women, and victims of sexual offense or child abuse offenses. There are specific statutes which prohibit the media from publishing material pertaining to these ongoing trials, and which, of course, has also been, our Indian acts also have similar provisions where a lot of credence is given to and protection is given to such persons. In Singapore as well, there are judgments which have recognized this right of the slightly more weaker sections, for instance, women, children who are undergoing certain sensitive cases, for the media to uh, not publish those kind of cases. Now, coming to the Indian jurisprudence. Now, all of this is pertaining to, just to give a broad gist of how internationally the jurisprudence has evolved. Now, in India, again, it has been very, very interesting. In terms of the developments that you see over a period of time, there are series of judgments where gag orders were passed. There are series of judgments where gag orders have not been passed. Now, the fundamental question would be under what circumstances gag orders can be passed and under what circumstances it cannot be passed. So, we will go through that case by case to analyze as to why gag orders were passed in the facts of those cases. And insofar as media trials are concerned, I think the jurisprudence in India is very well settled. India has borrowed principles and essentially said that even under Article 21, an accused has a right of fair trial. And if the media publishes anything that tarnishes his or her image in the eyes of the public or clouds the entire image of the public, where the person is tainted to be to be convicted of the offense even before the trial has concluded, that is something that is frowned upon. And the courts also have passed orders restraining the media from portraying people in certain negative light or negative perception, especially when the trial is still ongoing and nobody has been convicted, etc. At the same time, there are certain circumstances under which media has been allowed to report, especially things which are already in public domain. And if it is largely fair reporting of events that have come out in public domain, then the courts have not granted those kind of gag orders. And they have essentially said that as long as it is fair reporting based on assessment of facts which the media has obtained based on its credible information, then gag orders cannot be passed. Now, let us look at some of the cases in the past, historically, on how media trials have actually affected some of the important cases. Now, we go back to the KM Nanavati case of 1961. This was a case that Ram Jethmalani handled as a junior lawyer. Now, this was a case where the allegation was that Nanavati uh, shot his wife's paramour, that is Prem Ahuja, in a fit of rage. And at that particular point of time, this was a classic case which divided two communities, that is the Sindhi community and the Parsi community, because that is the communities to which the accused as well as the paramour belonged to. And the case received a lot of sensationalism and it was widely reported in the media across the country. Now, there was, and back in those days, during the Nanavati case, there was jury trial. Jury trials were abolished after the Nanavati case. And one of the reasons was also because of the media trial and the effect that media had in the minds of the jury and the judge who were deciding that case. Now, a perception was created that Nanavati, the person who shot the wife's paramour, Prem Ahuja, that he was actually a good person. There was a lot of positive reporting put about him. The fact that he stood up because he felt cheated, it was infidelity, and he did it in a fit of rage. So therefore, he should be excused. And he was a decorated naval officer, etc., etc. A lot of positive rhetoric was built, and that actually played in the mind of the media. Now that got overturned in the High Court because one of the grounds that Ram Jethmalani, along with the battery of lawyers who appeared, pointed out was the negative effect that media trial had on this particular case. And in appeal, Nanavati was convicted for murder. And of course, eventually it went to a presidential pardon for various other reasons. And that whole case just came to an end. And likewise, in 1994 case of Sanjay Dutt, then we can talk about the Nupur Talwar case versus CBI. Nupur Talwar case, more than Sanjay Dutt case, of course, was a case where, again, there was a lot of media publicity. And because he was a celebrity, there was a lot of focus on Sanjay Dutt's case to paint as if he was a villain or that he was not a villain. You had two sections of the media which pretty much divided public opinion. And all of this was being played out in the media and opinion polls to asking people whether you think he did it or not. All of this during the 90s was very, very prevalent. In fact, you would have TV show debates, which of course became more prevalent after 2000s, when there would be trial by media, where there would be online polling, where people could vote and say whether this person is is guilty of the offense or not. Then you would also have uh, various other debates where the witnesses would be called on TV and witnesses would be asked questions pertaining to the trial, and it was almost like a cross examination would take place by the news anchor itself, and then the news anchor would put a question to the audience and to the public at large to decide whether the person is guilty or not. Now all of this, over a period of time, there have been judgments where it has been frowned upon, but just pointing out that the Sanjay Dutt's case and also the Nupur Talwar case. Nupur Talwar, in fact, was a case which received a lot more media publicity. Uh, we all know the Nupur Talwar case, where a 14-year-old girl and the family's domestic help, Hemraj, both of them were found to be murdered. And it was a case where the CBI also, the investigation was done in a very poor manner, which was reprimanded by the courts as well in the acquittal order. And ultimately, the parents also came on prime time television. The parents were asked questions. The parents were asked where were they at this particular point of time. The CBI officers were called. And then, even after the acquittal order, the first acquittal order that eventually when they were acquitted, even after that, there was some reporting which was done. They were called to the media, etc. So all of this received a lot of sensationalism. And more recently in 2020, the Sushant Singh Rajput case, where Riya Chakraborty, the actress, she was framed in that particular case. And there was a huge media trial stating that she was the reason behind why Sushant Singh Rajput committed suicide. So there was a lot of scrutiny insofar as this is concerned. Now, let us get into the specifics of some of the cases and how the Supreme Court has come down heavily on media trials. The first case that I would like to cite is what Trivikram also mentioned is the case of Manu Sharma. Now, in Manu Sharma case, again, this was a case of Jessica Lal, where she refused allegedly to serve a drink to Manu Sharma, and Manu Sharma shot her. And initially, he was acquitted of the offense. And during the whole course of the trial, also, there were multiple media houses that published photographs to statements of suspects, accused, um, alleged confession statements being made, etc. And this is where Mr. Ram Jethmalani himself, he argued this matter. And while Manu Sharma's acquittal was overturned by the higher court, that is the High Court as well as the Supreme Court, the Supreme Court essentially made a very interesting observation at paragraph 303, subclause 11, where it stated that every effort should be made by the print and electronic media to ensure that there is a distinction between trial by media and informative media. So essentially, if it is an informative media which is merely reporting things that are happening on the ground based on credible material and information, it should be completely fine. But if it is a trial by media where the media itself decides and adjudicates the guilt or the innocence of an accused, that is something that the court said is against law, is against the constitutional protection of an accused to have a right of to have a right of fair trial before a competent court of law and not have anything published by the media or any other person influence the whole decision making process based on which the trial would be conducted. Because, as the saying goes, justice must not only be done, but must seem to be done. And that is the right of every accused, no matter how heinous the crime is. In India, which prides itself on democratic values, even when Lajmal Kasab, the Pakistani terrorist, was caught by the police, caught on camera, where there was absolutely no defense that he could have taken. Even he was granted a right to representation by a lawyer, right to a trial, and the trial also took place for a couple of years, where the state bore the expenses of keeping Ajmal Kasab in jail. But ultimately, he was given that right because of the fundamental protection that is given to the uh, accused to have a right of fair trial. The next judgment which I would like to rely on is the judgment of A.K. Subbaya versus B.N. Garudachar, which is a 1986 SEC Online Karnataka 353, a judgment of the Karnataka High Court, which is one of the judgments we typically cite when we fight for defamation cases. I'm sure Trivikram also would have cited this in many of his cases because I can see him smile. Uh, Essentially, what happened in this case was something was said in the legislative assembly against a certain person, and the same statement which was given in the House was also mentioned to the public outside of the legislative assembly. Now, one of the defenses taken was privilege, which the court essentially said there is no privilege because privilege is only when you speak something inside the house. The moment you step outside the house or the parliament, then there is no privilege. And the court also said that this is a question of balance. Everyone has a right to protect his reputation and character. The very story of defendant that he wants to make speeches or similar indicates that if injunction is not granted, irreparable injury would be caused to the plaintiff under the circumstances. And therefore, they balanced the equities and essentially said that there is no right to say whatever you want to say, because while there is a fundamental right of speech, there is also a corresponding duty not to defame the other and not to cause harm to any other person. I think that is where the rights, fundamental rights, and the duties of a citizen of India were integrated together, and the court came down with that principle. Likewise, in the case of Sahara India Retail Estate Corporation versus SEBI, reported as 2012-10 SEC 603. Again, in this case, the court steered towards grant of not granting an injunction, restraining any kind of media from publishing certain things which were published against the Sahara Group, essentially because the court said, as far as possible, the court must try and see if any other device or mechanism can be adopted to make sure that the trial does not get affected. Now, one of the ways in which that can be done is either postponement of the trial, or to have the trial in some other jurisdiction, or if there is any other via media that the court can come up with to ensure that whatever is reported in the media does not affect either the judges or the trial process itself from going on. So, therefore, the court again uh, did not grant an absolute gag order, but ensured that there is some kind of a balance that is done. Likewise, in the case of TV Today Network Limited versus Cognate and others, again, this is of the Delhi High Court, where a certain story was put up on Twitter, essentially showing that COVID protocols were not followed during the Kumbh Mela. And a post was essentially put saying that for Kumbh Mela, this is the COVID protocol which is not maintained, and referred to a festival uh, targeting another community, and essentially saying that the press has gone only against the minority community, which amounts to Islamophobia, because when the Hindus went for their COVID-19 and where they didn't maintain the COVID restrictions, you didn't say anything. But the moment the minority community has something else, you have gone against them. So therefore, the court, keeping in view the facts of the case and looking at the tenor of the tweet itself, said that this is a classic case where an injunction needs to be granted because of the malicious nature in which the tweet itself was passed. And likewise, in Oracle Stays Limited versus Nine Network Private Limited, 2022 SEC Online, Delhi 3597. There were certain defamatory articles which were made against Oracle Stays and which was published on the website inventiva.co.in. The article essentially said that there were fraud and money laundering allegations which were made against Oracle Stays. Oracle came up and said, what is the proof you have to show that there is any kind of fraud or money laundering? There is absolutely no investigation either by the tax authorities or under the PMLA by the ED. So these allegations on the very face of it are false. The court analyzed this and said that it is a classic case of a publishing house being a small company publishing misleading articles to personally profit from increased viewership of these controversial articles. The defendants have sought to harm the reputation and goodwill of the plaintiff by publishing defamatory articles. And this is where they said the intention itself is completely wrong, and we are not going to allow this to happen, especially if there is no material, even prima facie, to show that there is any kind of allegations of fraud and money laundering against the plaintiff company, then an injunction can be granted. Likewise, there are several other judgments like Kaira View versus Hindustan Times, again of the Delhi High Court, where the defendant had made allegations against the plaintiff of child abuse and abuse of the pet dog, and the judge actually went through the video and said, I find absolutely nothing, even prima facie, to suggest that there is any kind of a child abuse or misogyny or abuse of the pet dog. And ultimately, they said that a undoubtedly, a person has a right to criticize the views expressed by an individual, and such criticism would be covered under the right to free speech. However, vicious attacks cannot be made on the character of a person under the guise of journalistic freedom and free speech. In my prima facie view, there is nothing in the aforesaid videos to substantiate the allegations of child abuse. And therefore, on this ground, the allegations were completely held to be baseless, and a gag order was indeed passed. Then came the case of Swatantra Kumar versus Indian Express, 2014 SEC Online, Delhi 210. Again, the name of a retired Supreme Court judge was linked to a sexual harassment claim made by an intern, along with Justice D.K. Ganguly's name. This is all in the public domain, so therefore I'm stating all of these names. And the court ultimately looked through the material and said that there is absolutely nothing linking those allegations with the retired Supreme Court judge. Nothing has been produced by the other side to essentially show that there is any kind of a link of sexual harassment with the intern. There is no complaint, etc., made. And therefore, a gag order was passed, essentially, where the right of reputation of a person trumped the Article 19, freedom of speech and expression of the journalist, to say that in the guise of journalistic freedom, you cannot publish anything and everything that you want. Likewise, the next judgment of GMR Infrastructure versus Associate Broadcast Company, 2018 SEC Online, Delhi 6866. This was a case where TV9 broadcasted a story regarding the functioning and operations of IGI Airport, where they said that there were certain wrongdoings there. Again, the court went into the evidence prima facie and said that in view of the extensive factual corrections and counter responses, this court finds that there is a prima facie case of defamation in the show, and ultimately, an injunction order was granted in this case because the other side was not able to justify that there was indeed something wrong with the functioning of the airport, as was stated to be mentioned in the publication. Uh, Again, the judgment of J. Sudhir Chandrasekhar versus T. Lokaprakash. This is the judgment which is authored by Justice N. Kumar. Very well written judgment, essentially, where he says that publishing highly defamatory article in newspapers without verifying the truth is opposed to journalistic ethics. Now, in the facts of this case, what had happened was there were certain allegations which were made against a government employee, stating that certain procurements were taken, hinting at allegations of bribery and certain fraud which had taken place within the department itself. Now, the evidence did not show that the journalist made any effort whatsoever in order to find out the veracity of these allegations. The evidence also revealed that the journalist did not make an effort to verify what is the source of the information, go to the source of the information to verify that this is indeed what had happened, and therefore there is a right to publish. Everything was based on hearsay, which was not even verified, and verification not to the extent of what a CBI or an investigation agency does. There was not even a small effort made in order to identify some kind of a source and verify its authenticity. The court said that this is malicious and every person has a right to have his reputation in fact intact, and ultimately held that an injunction order could be granted. Now, there are certain regulations which have been framed. That is, I don't want to get into the gist of it, but the Cable Television Networks Regulation Act of 1995, the Cinematograph Act of 1952, and various advertising program and advertising codes which have been prescribed under the rules of the cable television network rules, which essentially prohibits the ad agencies and persons, media agencies, from publishing things which are prima facie not in good taste, which are obscene, or which are likely to defame someone. Just as a broad gist of it, which I'm not getting to the specifics of it, but there are several guidelines which have been issued, which the media is required to follow in order to ensure that there is a balance which is struck between the right of an accused for fair trial versus a right of a person to speak under Article 19. And that is a balance that has been struck by the press themselves in their own regulations. In fact, the regulations go to the extent of saying that if there is a choice to be made between freedom of speech and expression of the press versus the right of an accused to have a fair trial, the right of an accused to have a fair trial must trump the freedom of speech and expression. And those are guidelines that have been issued by the press bodies themselves to the press and journalists to ensure that there is fair and proper reporting in the country. To what extent this is followed, that is a question for all of us to ponder, whether it is really happening or not. But regulations are definitely there. Now, insofar as the other side now, all along we pointed out cases where court has granted an injunction order. Now let us also look at situations where court has not granted an injunction order. And now there are a couple of cases which need a special mention. One is Nilesh Navalaka versus Union of India, 2021, SEC Online, Bombay 56, where at para 355, the audience will please note that the Bombay High Court has laid down restraint on media houses for publishing matters relating to one, death by suicide or intruding on the privacy of the deceased person. This is because this pertained to the Sushant Singh Rajput case, which went to the Bombay High Court. There was a lot of reporting, even in this case, which it became sensational because obviously it involved a celebrity. So the court laid down guidelines stating that you should not and you should have a lot of restraint when you are publishing matters relating to death by suicide. Prejudice caused to an ongoing investigation by referring to the character of the accused or the victim. Three, holding interviews with the victim, witnesses, and or any of the family members and displaying it on screen. Four, analyzing witness statements that are vital for trial. Five, publishing a confession allegedly made to a police officer by an accused as a piece of evidence without letting the public know the nitty-gritty of the Evidence Act 1872. Printing photographs of an accused and facilitating his identification, or disclosing confidential information and reconstructing crime scenes. Now, this again, on countless occasions, we have seen this happen in the media. So the Bombay High Court has frowned upon this practice and essentially said that if you are reporting something that is in public domain and essentially saying a certain FIR has been filed by X against Y is an accused, investigation is ongoing, there is nothing wrong with this. But if you go to the extent of saying ABC are the witnesses in this, let's reach out to ABC for a statement. Let us find out from the police whether any confession statement has been made. And if indeed an alleged confession statement has been given, which anyway is inadmissible in evidence, publishing that in the media to taint the accused, all of this and analyzing witness statements, all of this would be in contravention of law. And the Bombay High Court has specifically frowned upon this. And the observations made in Nilesh Navalaka case has been followed by our own High Court and various judgments, which I'll come to subsequently. And likewise, the Reliance Petrochemical case versus the Indian Express, which is again a 1988 4 SEC 592 case. The Indian Supreme Court in this particular case relied on the US principles of present and imminent danger. That is, what is the present and imminent danger before issuing any gag order? If there is no present and imminent danger of some prejudice being caused, then injunction orders restraining the media from publishing certain information should not be granted, is what the test was. And in the facts of the Reliance case, now there was an ex parte order which was passed, and that interim order was continuing over a period of time. Now, that was with respect to the debentures which had to be subscribed by the public. Now, because the debentures were already subscribed by the public and it was already oversubscribed, the court balanced the convenience and said that let the information be put out in the public now, because no prejudice would be caused to Reliance because the debentures have already been subscribed. And therefore, applying the present and imminent danger test of United States, the court ultimately said that the public have an obligation and a right to know what is happening in the world today. And the media has a obligation and also a right to keep the people informed of the developments. And therefore, they said that the gag order should not continue any further at para 37. And likewise, in the LIC versus Manubai D. Shah, this is a 1992 3 SEC 637. In this case also, there were certain allegations which were made against LIC and its practices. LIC published a particular report. Somebody else said, no, this is completely wrong, and these are all the allegations against LIC. LIC published that. Thereafter, LIC refused to publish a rejoinder which was published by Manubai D. Shah, controverting some of the replies that were made by LIC. And so he took them to court and essentially said that LIC is state within the meaning of Article 12 of the Constitution of India because of the public functions that it discharges. And being a public body, it is under a right to publish everything that the citizen brings to the notice of LIC. And he's essentially said that his right of freedom of speech and expression has been curtailed by LIC because LIC refused to publish that. The court ultimately said, yes, fundamental right has indeed been violated, and called upon LIC to publish the information on the LIC portal, and refused the gag order. And likewise, in 2013, the Asaram Bapu versus Union of India, which was reported as 2013 10 SEC 37, the Supreme Court again declined the request to impose a gag order in the media because on the content in the publication made in certain dailies as well as coverage on electronic media, because it was already out there in the public media. And the court perused the publications and held that injunction order against the dailies were not required because all of this information was already there and you can't curtail free speech. And that is why free speech was not granted. Then came the judgment of Dr. Shashi Tharoor versus Arnab Goswami, where Arnab Goswami had, in his television shows, had come up with series of interviews and shows where he essentially tainted Dr. Shashi Tharoor to be the murderer of his wife, where the trial was still ongoing. In fact, the charge sheet was yet to be filed against Shashi Tharoor, but Arnab Goswami went to the extent of having television debates, calling Shashi Tharoor a murderer and calling upon him to come up with the true facts. And in the facts of this case, it was quite interesting because the court refused to pass a simpliciter gag order because Justice Manmohan went through each and every statement that was made by Arnab Goswami, and Mr. Sandeep Sethi, who was appearing for him, was able to show that each and every statement is corroborated by information which is already there in the public domain. And the court goes to the extent of saying that all of this is corroborated. This requires a detailed trial. We cannot pass a gag order because that will amount to a super injunction, which prevents the administration of justice. And the court also makes observations saying that when you are a public figure, you need to have a thicker skin, in effect. You can't be free from public ridicule because that is the nature of the job also that you have taken. Of course, that also has certain limits. Just because you're a public person doesn't mean that you can simply be defamed. But if there is criticism of you based on what is already there in the public domain, then the courts have held that no gag order can be passed in such circumstances. And that is where the Delhi High Court passed this two-pronged test of necessity and proportionality and said that if these two tests are satisfied and there are no reasonable alternative methods or measures that are available to prevent the risk, then a gag order should not be passed, because freedom of expression is one of the essential foundations of a democratic society. And that is what it said. Likewise, some of the other recent judgments which have been passed by the courts. One is, if you recollect, Trivikram, during the COVID time, there were there was a series called The Crime Stories, India Detective, and this was on Netflix, where Netflix had a series of documentaries where some of the live cases were reported live, and the police interviews were taken, and the police were interviewed as to how they're catching the so-called accused, and the so-called confession statement that was made by the accused was also broadcast on the Netflix series. So ultimately, this content obviously prejudiced the fair trial and the right of fair trial of the accused. The accused went to court, went to the Karnataka High Court, and there was an injunction order which was passed earlier, and ultimately it was challenged before the court, and the court ultimately said that initially they said that an ex parte order needs to be passed, and an ex parte order was passed, but later on an application which was moved, the court vacated that injunction order on the ground that there was suppression of facts in the facts of the case, because the accused had specifically had a agreement with the media house saying that all of giving consent that all of the information during the trial could be published by the media for a handsome consideration, and because there was suppression of this fact, the interim order was ultimately vacated. But in the first blush, a gag order was indeed passed saying that this affects the entire trial process, but it was vacated on the ground of bad conduct and bad faith, relying on Morgan Stanley judgment, essentially saying that for an injunction order to be passed, your conduct should be absolutely above board. And because there was suppression of facts, on facts, they said the injunction order, the gag order needs to be vacated. Likewise, the next case is of Central Bureau of Investigation versus Netflix, which pertains the famous or the infamous Sheena Bora case, which still gets a lot of media attention even as of today. It's one of those cases where even a Netflix series was published, and a objection was taken saying that, in fact, an objection was taken by the CBI saying that the Netflix series should be stopped, but that was denied on the ground that, one, the CBI did not oppose to the earlier books or the two movies which were based on the Sheena Bora case. The CBI did not take any objection to that. And secondly, the information based on which the Netflix series was published was on information which was already there in public domain. So therefore, nobody is crossing the line. And the gag order eventually was uh, refused, and the Netflix series, to the best of my knowledge, is there even as of today. Then comes the case of Darshan Sridhar versus Union of India, that is the Karnataka High Court case of 2024, where there was an ex parte gag order which was passed, essentially restraining all the media houses from publishing, printing, or disseminating confidential information contained in the charge sheet in relation to the crime, which was registered by the police station. And essentially, the court said that all of this amounted to interference with the process itself. Of course, insofar as his bail is concerned, that's a matter that went all the way to the Supreme Court, and the bail has been cancelled. Uh, the next case again would be the most recent case of the Dharmasthala case, that is Kudla Rampage versus Harshendra Kumar and others case, where civil court, where in this particular case, if I'm not mistaken, more than 350 persons were named as defendants in this particular case. And the civil court granted an ex parte injunction order on July 18th, because essentially the case pertained to certain bodies that were allegedly buried in Dharmasthala at the instructions of the temple management, to hush up certain murders and rapes which allegedly have taken place in the premises. And one of the persons who came out turned out to be a whistleblower and highlighted all of this. Now, at first blush itself, the civil court passed an ex parte injunction order, which essentially against all the 355 defendants, essentially saying that they don't have a blanket right to taint everyone as in such a bad or a poor light, and granted an ex parte injunction. Now, Justice Nagaprasanna, in challenge to this particular order, set aside the ex parte injunction order, but that injunction order was set aside on the basis that principles under Order 39 were not followed, since the ex parte order did not contain cogent reasons, again relying on various Supreme Court judgments and the well settled jurisprudence that if you're passing an ex parte order, it has to be by a detailed reason. On that basis, the injunction order was the ex parte order was set aside, and it was remanded back to the civil court for fresh consideration. And to the best of my understanding, this order was also challenged in the Supreme Court, and the Supreme Court has not interfered with the order as well. And then, of course, you have the more recent sensational cases of Ranveer Gautam Alabadia versus Union of India, where Samir Raina and Ranveer Alabadia in a YouTube show called India's Got Latent, where certain posts, uh, certain things were said on the show which hurt the sentiments of the public, and the Supreme Court came down very heavily on that, saying that these kind of statements ideally should not be made at all, and granted some kind of an injunction order restraining them. And in fact, they had to also issue a public apology saying that they will not do something like this. The court came down extremely heavy on that. Now, it's a bit debatable as to whether the measure taken by the Supreme Court really impinged on the freedom of speech and expression, or whether whatever these artists did in the guise of artistic freedom falls within the exception under Article 19(2) of the Constitution of India. That is something that will always be up for debate. So I will stop here and I will invite questions from the audience, and Trivikram, any questions that you have as well. As I pointed out earlier, I'd like to make this as interactive as possible.
Before we pitch into the Q&A session, sir, absolutely a stupendous presentation from your end. Many thanks for that. Of course, we have already got two online questions, and I would also like to make a mention to the participants that if you have any questions, you may hit the hand raise button. I would unmute you. Parallelly, you can also send it through the chat box so that I'll be posing that to the resource person. Couple of questions, sir. I have it from my end, and in mix and match with the online questions, we'll take it up. Uh, One thing, of course, we have made a mention about this, but specifically the jurisdictions, sir, whether the first forum would that be a civil court, or superseding that in few circumstances, if we can approach the High Court under 226, is the first question.
Right. So that's a very good question, Srivikram. So the answer to that is this. So our Karnataka High Court does not have an original jurisdiction. So anything in Karnataka obviously would have to go to the civil court. And the civil court has wide powers under the CPC itself to entertain all types of suits unless they're specifically barred by law. So therefore, by law, the civil court would have jurisdiction to entertain even a defamation suit. Now, in terms of strategy and advice, if a client were to come to me, I would always advise them to go to the civil court first, because that is the most obvious and natural choice insofar as getting an injunction order is concerned. Point number two is, under what circumstances can you go to the High Court? Now, in a High Court as well, unless and until you're able to make out that the respondent is a state within the meaning of Article 12 of the Constitution of India, a writ may not even be maintainable. But a writ, of course, would be maintainable if you are challenging the refusal of the civil court to grant an injunction order. Then under Article 226, 227, a remedy always lies to a person to go knock at the doors of the High Court and say that an injunction order should have been granted. It has not been granted. Now I'm asking you to grant me that injunction even before notice goes to the other side. So unless and until that remedy is exhausted before the trial court, I would say that the remedy before High Court would not even be maintainable. Now, point number three is, let us assume that it is one of the government bodies, or even if you want to make the Ministry of Information and Broadcasting as one of the respondents to the particular case. Even in cases like that, it would be the suit that would have to be filed first, just because the Ministry of Information and Broadcasting or any of the government bodies is not taking, which is largely a facilitator and a supervening body, which is looking into all of this, and not the prime defendant who has issued or made those defamatory statements, since they are not the main defendants. It would always be better to go under a suit jurisdiction itself and exhaust remedies there.
Extension of this question, sir. In few circumstances, the aggrieved party could be the society at large or a particular segment in the society who cannot voice it out. But at the end of the day, they are aggrieved party. Therefore, in those circumstances, who would be the plaintiff, or would the writ jurisdiction again give us some opportunity of relief, or would that be a forum of recourse is the question.
So, under law, defamation can also happen to class of persons, not just one person. And those class of persons are also entitled to be plaintiffs in a suit for defamation and file an action against the defendants asking for the order to be passed, especially if the sentiments of that community or those class of persons, which is a common thread to all the plaintiffs, has been violated. Then the right is most certainly there for them to come together as co-plaintiffs.
Would a representative suit be a the kind of recourse before the civil court?
So, under the CPC, a representative suit can be filed, but a representative suit under Order 1, Rule 8 of the CPC, if I'm not mistaken, uh, essentially states that if there are people who are also agreed, similar to the plaintiffs, but they are not parties to the suit, then it prescribes, even the Karnataka amendments also prescribe, that there is a certain way in which the plaintiffs need to have a paper publication, and those people need to come on board. They need to give their consent. There needs to be a representative who will be representing and acting on at their behest. Once all those rules and procedures are complied with, then it becomes a representative suit.
So we will take up this question from Mr. Pawan Srinivas. Do courts apply different tests for gag orders in respect of the reputation of a company? Example, allegation against the quality of its products versus gags in respect of the reputation of an individual.
So there is no different test as such which has been laid down insofar as company versus an individual, because under law, a company is also a person, and a person is entitled to agitate its rights, including its right not to be defamed. Now, the test that would be for an individual would also be similar to that of a company. So, a company, for instance, you have said that if it is allegations with respect to quality of its goods, now it has to be of such a nature that on the face of it, the company should be able to establish that this is absolutely scurrilous and false, and it has been done with a certain malice. There is no higher threshold which has been given to a company as such, but the similar threshold that would be even for an individual's reputation, saying that these are the ingredients of defamation, would also apply even insofar as a company is concerned.
So, so the next question would be the role of intermediaries. Most of these defamation or the videos that get circulated would be through a particular platform, more particularly the social platforms. And what would be their role? And when there is a directive or an injunctive order from a specific court, what is the exact role of the intermediaries? And to what extent are they bound by that?
So the role of the intermediaries become absolutely crucial, especially in today's time and age, because all the defamatory material, I mean, gone are the days, newspaper is one thing, of course, but what really spreads like wildfire is what is posted on Twitter, Instagram, Facebook, and the likes. So, insofar as the intermediaries are concerned, again, the law is very, very clear. It starts with the Shreya Singhal judgment of the Supreme Court, where the court has passed specific guidelines, and there are intermediary guidelines also, essentially which state as to what are the roles and responsibilities of an intermediary. Essentially, an intermediary cannot be liable insofar as what is being published and posted on the websites on their platforms, because they have no control, because it's like a blackboard where somebody comes and puts up something. They cannot be restrained from putting up something, stopping somebody from putting up something, because that's like a blackboard where anybody can put anything they want there. But at the same time, all the intermediaries, in addition to these rules, the intermediaries themselves have their internal regulations. For instance, Facebook, Instagram, Twitter, all of them have their own regulations where they have stated, they have their internal policies where if anybody is aggrieved by a particular defamatory material, or if images have been morphed, etc., where there's an invasion of their privacy, a representation can be made to these platforms, and the platforms have the ability to take them down on their own, even without a court order. That is one. Secondly, let's assume that they don't take it down, and which is why intermediaries are always named as one of the defendants in a gag order injunction suit. Then, the moment there is an order which has been passed by the court, the intermediaries would comply with it as soon as there is an order, because that is what their internal rules also say, and that is what the Shreya single judgment also says, saying that once there is an order, within 48 hours or 72 hours, the intermediaries are required to take down whatever is there on their platforms.
Yeah. Ask few questions, sir. In case, while a suit is filed or perhaps a writ or whatever, a case, we will use the word case, the defendants or the respondents, the most important respondents or defendants are skipped, who are the most necessary and appropriate party. What would be the impact of the order that is already obtained? We always have the option of impleading them at a later point of time, but then there would be a lot of damages which would cause and which would continue, and the very purpose of the obtaining the gag order would run futile. So
That's correct. So if you don't name the right defendant to a suit, the only way in which the entire process would get affected is the implementation of the order. Because there is no way to implement that order if the defendant itself is not there. You'll go to the defendant is like, I'm not even a defendant here, why should I comply with that order? So it's only the implementation, but it doesn't take away the order itself. The order, of course, is there, but it's just that it cannot be implemented. And because it cannot be implemented, therefore it is as good as not there. So therefore, it is important to implead the right defendants to the suit, obviously, and which is why, as I told you, even in that Dharmasthala case, there are more than 350 defendants, which is what the High Court judge also comments, saying that there are more than 350 defendants who have been made parties to it.
in continuation of the same thing, sir, the question is, suppose 350 parties would stop passing on unwarranted comments or whatever the case may be. 355th person, if he starts doing the same act, how would this gag order have any impact is the next question. My
Sure.
question
So
is, if I have to rephrase and crystallize it, suppose I have made 8 defendants, and the ninth defendant, now that because there is no order against him, he starts playing the mischief.
that's correct. I understand. So in most cases, who your defendants are would be clearly identified. So you would know who are the persons who are actually defaming and spreading this misinformation. It would largely be a journalist or a person, and it would largely be uh, propagated and sent through the intermediaries. Now, let us say some other person is also doing it, and let's say a lot of public, etc., are talking about it. Then, of course, you can't get a sweeping injunction order saying nobody can talk about it, etc. But the moment you have an order essentially saying that there is a restraint restraining the publication of it, that itself should be a deterrent for your 356th and the 357th person from saying anything contrary to the order. And if that person continues doing it, then obviously that person can be treated
He
as a
should be hauled
defendant
for contempt.
and called upon to comply with it.
Right. Yes, sir. We'll take a few more online sessions before we wind up today's session, sir. Mr. Raghavendra Pai, sir, ex parte gag orders are passed by courts without a formal hearing. How does this fare in the question of balancing of two fundamental rights, considering it may be used a tool to suppress information about allegations against affluent and powerful individuals.
That's right, and that's the whole theme of the presentation itself, that
Right,
you
right.
really have to balance the two interests. And typically, even if you're looking at defamation cases, the cases that you would have filed, the cases that we have also filed. Now, in terms of strategy to get an ex parte order, what is it that you need to tell the judge? You need to tell the judge your client's story. And while you're telling your client's story to the judge, there is always this overarching principle that, of course, the other person has a right of speech and expression, and has a right, especially if it is a media, to publish whatever they want to publish. And obviously, being rich and powerful, I can't get a blanket gag order. But what I need to show strategically is this: I need to show that on the face of it, what has been published, even prima facie, is absolutely defamatory and false on the very face of it. The defense of justification of truth will not even fly prima facie. For instance, one of the cases that I relied on, the Oraval case of the Delhi High Court, where there were allegations made against the group, essentially saying that there was money laundering. Now, this is easy because if you're able to show that there is absolutely no money laundering investigation that has been done by any authority, how is it that a private citizen has some information that there is some money laundering going on in the company? And obviously, if that is the case, then they would be called upon to prove it. So at the ex parte stage itself, it is to poke holes in the statements made by the other side itself, which prima facie shows that all of this is false and defamatory on the very face of it. I can give numerous instances. In fact, even during 2020, when people were tired of the entire COVID episode, there was a big sensation of the drug scandal in the Karnataka movie industry, if you recollect that. There are a
And
couple
right.
of people who went to jail, but for one of them who went to the court, who we got an injunction order, we were able to show that there is absolutely nothing linking the so-called drug mafia thing with that particular actress, and there is no question of drug peddling, etc., because the media would not even be able to show prima facie that there is any such link. So that is the standard that needs to be shown at the ex parte stage itself, because the other side is not being heard. That is the standard of proof that needs to be shown. And obviously, the media houses always come later and then they say that no, 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 all of this is fair reporting. I got this information from so and so. And it's also a question of trial.
But of course, we have been seeing the trial courts have been very liberal in granting gag orders of late. Without digressing, sir, but still, I would like to pose this question and widen up today's session. We have been practicing abroad and within India. So, what is the major difference, and what is your comment for the upcoming lawyers who are also intending to practice just like you?
Okay, so I think in terms of native intelligence, in terms of the quality of lawyering, in terms of the lawyers that we are, I think the quality that we have in India is excellent. And this is something that even the foreign counterparts also will say. There is a lot of talent pool in India, and it is very well respected across the world. In fact, students from leading law schools, a lot of them have gone abroad. A lot of them have joined barrister chambers abroad, law firms abroad, doing exceedingly well. Some of them have also become managing partners of internationally leading law firms as well. People who have put in 25, 26 years. So it's all phenomenal achievement. But I think there are certain things that we can definitely learn from our foreign counterparts. One is the art of succinct and clear drafting, because we are moving towards an era of written advocacy. There is just no time for either the judges or the arbitral tribunals to hear laborious arguments. So I think the skill really is in crystallizing your arguments, crystallizing your written submissions as short and as succinct, at the same time comprehensive as possible. I think the art of written advocacy is something that all of us lawyers can learn from our international counterparts, and also a lot of professionalism. So the way in which cases are handled by the counterparts in Singapore, US, UK, there is a lot I think that we can definitely learn and we can improve. But I must say that overall, from whatever my limited experiences, that the talent pool in India is fantastic, and we are no less than the top lawyers across the world.
Thank you, sir. Of course, due to paucity of time, I think we'll have to stop here. But otherwise, you've been very active on different facets of law, more particularly ADR, mediation, arbitration, different facets. And definitely, in the days to come, we will have more of these discussions. And I would also like to mention that you're also part of the Advocates Academy. In fact, I should have mentioned it. You yourself, you are part of the team of this academy, Advocates Academy. Sir, it was a great honor and a privilege to have you on this forum as a resource person. Once again, sir, on behalf of Academy, on behalf of Advocates Association Bengaluru, and my personal behalf, many thanks to you, sir. Thank you so much.
Thank you so much. It was a pleasure being here, and look forward to future collaboration as well. Thank you.
Thank you, sir. Yes.